So let's now discuss about the powers of the president, or what we call presidential powers. Okay. So, of course, the first thing that would come into mind is the power of the president to appoint his officials. Okay. So, of course, we have this appointment power of the president. Okay. So ano ba ang limitations ng appointment natin? Okay? So, if you can recall our Article 7 Section 16, di ba? So, of course, as a rule, the president has the power to appoint its officers and employees. Siyempre, the reason why he has this appointment power is, of course, for the president to appoint someone whom he would have trust and confidence, di ba? Yung pleasure, di ba, isasabi at the pleasure of the president, it has to be one in which the president can repose his full confidence, his full trust, that he would be able to do his duties as assigned to him in the office that is going to be subject of the appointment. Okay, but of course there is a limitation as to the appointment, because remember, if you're going to recall your discussions on the law on public officers, di ba? If you can recall the discussion, of course there are formalities to an appointment, di ba? So meron yang parang commission, di ba? Then there should be an acceptance by the appointee. Then there is a required oath, okay? So yun yung mga standard na requirements sa appointment. Wala na yon, tapos na yon. Walang problem yon. That's the general rule when it comes to appointment. Siyempre, yung appointment, pwede rin kasi i-delegate yun sa alter egos nila or sa offices. Okay? But now, the next question is this that absolute? Pwede lang ba mag-appoint ang presidente ng basta-basta? The answer there is may limitation yan under Article 7, Section 16. So, may limitation siya in a sense that, well, the appointment is valid, but there is a need of ratification by the Commission on Appointments. Okay, so may mga certain appointments na required ng ratification, and to be particular, not necessarily ratification, confirmation. I have to emphasize, there is a need for the Commission of Appointments to confirm, okay, to confirm the appointment. Okay, so it's an act of ratifying or giving assent to the appointment of the president. So, ang role ng commission on appointments is more of a check and balance. This is part and parcel of your checks and balances under your separation of powers. Bakit kailangan nitong provision na to? Let's remember that itong mga naka-enumerate sa Section 16, di ba? So, ano ba yung naka-enumerate sa Section 16? So, heads na executive departments. So, that would be your cabinet secretaries. That was ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other appointments whose appointments are vested in him in this Constitution. Okay? Kung papansin niyo, may second sentence yan na pwede rin siya mag-appoint ng kahit sino. So, ibig sabihin lang niyan, pwede mag-appoint ng president, but insofar as yung enumeration sa Section 16, yung cabinet secretaries mo, ambassadors, public ministers, yung mga AFP officers na colonel pataas, or kasi sa Navy, ang equivalent ng colonel nila is naval captain, 'di ba? 3 araw 'yun eh. 'Di ba sa kanilang mga epaulets sa Australia nila, 'di ba, may symbols 'yan. Pag naval captain ka kasi or colonel, 3 araw 'yun eh. Yung bagay symbols na three suns 'yun eh. Okay? So, yun yung naka-list, di ba, sa Section 16. Now, of course, ano mga issues natin dito sa Section 16? Number one, is the list exclusive? The answer there is yes, it's exclusive. I think it's already determined in the case of Sarmiento versus Mison, that if it's not listed there, you're not covered by the requirement of confirmation by the Commission on Appointments. So I think if I can recall the Mison case, this involves whether or not ang Commission ang Bureau of Immigration, ang Commission Bureau of Immigration needs the needs the confirmation. Sabi ng Supreme Court hindi kasi wala naman sa listahan 'yon, di ba? It also includes sa police force. Kasi sa police force natin, di ba civilian na yung police force natin after 1991. Hindi rin required hindi rin required ng confirmation ng Commission on Appointments. Okay? Kasi wala naman din nakalagay sa konstitusyon na yung mga, although nakalagay dyan naval rank of colonel or naval captain, it refers to the armed forces of the Philippines, not the civilian arm like the Philippine National Police. Okay? So hindi siya kasama doon sa ano. Okay, ba't siya importante? Kung napapansin niyo, 'di ba, ang tataas kasi ng ranggo ng kailangan ng confirmation. Kasi syempre, you have to of course they want the commission of appointments wants to have a say as to sino ba 'tong mga appoint na to. Baka naman may mga records to, di ba? Kailangan mas scrutinize din nila further. Kasi, of course, I think it's reasonable and of course, the reality is, of course, the president would appoint anyone naman kasi, di ba? But sometimes you have to do check and balance, di ba? Kung deserve ba talaga niya ma-appoint, di ba? Kaya lalo na ang pinag-uusapan natin dito are higher positions, di ba? These are higher positions which they should be more responsible or more circumspect in dealings. Remember na pag mataas na ang hierarchy mo, you deal with far more important matters to be served, okay, to serve the country. Next question is this, okay? Dahil sa Section 16, merong klase ng appointments na pwede nyong ma-discern. So, you would have a permanent appointment and an ad interim appointment. Okay. So, ano yung ad interim appointment? So, ang ad interim appointment siya ng presidente. Pero remember that there is a requirement of confirmation by the Commission on Appointments. So, habang hinihintay mo yung appointment mo ng Commission on Appointments, you're technically ad interim. Okay? You're ad interim. So, ad interim siya because it's conditional. Kasi ito kasi yung dalawang sitwasyon na pwede mangyari. Either, syempre, number one, inappointan ka. So, ad interim appointee ka. In-approve ka, kinonfirm ka ng Commission Appointments. Well and good. That's the first situation. The second situation is, hindi ka na ad interim appointment ka. Inaabutan ka ng close ng session ng Congress. So, usually, if Congress stops session, your ad interim appointment can be, what the President does is, they're going to just renew the ad interim appointment. Then, magkakaroon ulit, hintayin ulit yung commissioner appointments. Okay? Siyempre, the third one is, hindi ka in-approve, rineject ka. Pag rineject ka ng commissioner appointments, hindi ka pwede mag-hold ng office. Diba? So, yun yung doon. So, pag nireject ka ng commissioner appointments, you cannot hold your position. Diba? Or ma-hold ka. Okay? Or if you might have heard the term, na-bypass ka. Diba? Na-bypass ka eh. Okay? Then, of course, another concern with respect to appointments is, okay, how are you going to distinguish yung ad interim appointment in relation to other kinds of appointments? So, balik ulit tayo sa law on public officers. So, di ba, sa law on public officers, dalawa na naman appointments dyan eh, permanent and temporary. I think I mentioned it a while back, di ba? I think, if you can recall, di ba, ang permanent appointment, may security of tenure ka. Okay? So, for example, sa civil service, plantilla ka. Di ba? Kung plantilla ka, may security of tenure ka. Hindi ka pwedeng alisin. Kasi once na you get terminated without due process, you can question the mode of termination. Di ba? Pero pag temporary appointment ka, although qualified ka on paper, but if your appointment is temporary, regardless of what happens, hindi mo ma-attain yung permanent position unless there is really a formal appointment for that permanency. Okay? Kaya nga di ba may mga rulings ng Supreme Court dyan na pag kahit na sabihin mong matagal ka na doon sa service, tapos parang kaano man yung rank, it doesn't give an automatic assignment na permanent ka na. Temporary ka pa rin for all intents and purposes in the eyes of the law. Diba? So yun yung doctrines, daming cases about that. Now, kung tutusin right now, hindi na ganun ka prevalent yung mga temporary appointments. You know why? Kasi, sa totoo lang, ang daming vacancies. Diba? Or yung iba, hindi pinipila pa yung posisyon. Diba? So, sa totoo lang din, marami na rin qualified, okay, sa position to apply. Diba? So, I'm not going to dig deep on how the process is being done, pero the point is, ang dami na rin kasing marami kasing qualified appointees na ngayon kung tutuusin, that you cannot, kaya pansinin niyo yung mga decision sa public officers on temporary appointments. Parang assumption is no one doesn't, parang ang dating kasi parang konti lang yung gustong mag-government. Kaya nagkakaroon ng temporary assignments, di ba? Or temporary appointments. But nowadays, it's a little bit different kasi although, di ba, ang ginawa, because of the SSL, di ba, everything's kind of, except teachers, kasi madaya yung teachers, ang baba na SG ng teachers. Sorry for the teachers natin talaga, di ba? Pero syempre kung ordinary offices pinag-uusapan natin, di ba mataas ng SSL. So kung tutusin, competitive na ang pay sa government compared sa private. May instances pa nga distorted doon sa government, may mga instances na mas distorted sa government. Gusto iba maggobyerno, di ba? So that's the point there. Okay? So yun ang nangyayari, di ba? So ngayon, kung tutusin, wala ka ngayon, even in jurisprudence, walang masyadong issue na tinatanong on temporary appointments kasi most of the time, mga appointments ngayon are more or less permanent na, okay? Pero for purposes of our discussion, syempre, the same pa rin naman yung doctrine, may mga cases na kino-confuse nila yung temporary sa ad interim appointment, okay? So kino-confuse nila yon. Well, if you in language naman, pag sinabi naman kasing ad interim, para na siyang temporary, okay? Temporary. Kung isipin mo, kasi ad interim para pansamantala lang o inassign ka lang doon dahil at a certain time baka magbago yung kondisyon, di ba? Pero for purposes of discussing it under the law, okay, kasi kung tutusin, kung normal na usapan lang, pwede mo sabihin, ad interim lang yan, di ba? Kung tutusin, pwede nyo gamitin yun grammatically. Okay? Pero for purposes of your for that purposes, di ba? Ano to? Iba yung ad interim, okay? Iba yung ad interim sa temporary. So legally kasi pag sinabi ad interim, that refers to the appointment sa section 16 article 7 ninyo, okay? So yun yung doon. So that's your ad interim appointments, okay? So yun. Okay, so that's your so that would be your, so yun yung difference na ad interim appointment ninyo, di ba? The difference of your ad interim appointment with your anong tawag dito? The difference of your ad interim appointment is yun yung naka-pertain sa constitution when we refer to the term ad interim appointment, okay? All ad interim appointments for purposes of public officers law, they are also permanent appointments. The only difference is that kailangan mo ng confirmation. So, lumalabas, permanent siya but subject the appointment of the president with as to ad interim appointments. They are permanent in nature. Okay? But insofar as those listed in Section 16, Article 7, they are permanent but subject to the confirmation of the Commission on Appointments. So, kinaklarify na ng Supreme Court kasi 'di ba kanina may binention ako 'di ba formalities na appointment. natupad lahat ng formalities of appointment doon sa ad interim appointment. May papel ka, may komisyon ka, pirmado ng presidente, inaccept mo, nag-oath ka. Okay? So, lahat ng elements sa appointment nandun, doon sa, as insofar as public officers are concerned. May condition nga lang on confirmation. So, ad interim appointments are permanent appointments. So, that was discussed doon sa kaso ni, yung difference niya was discussed doon sa kaso ni Matibag versus Benipayo. Okay? So, si Matibag versus Benipayo is the jurisprudence that you're going to look insofar as the difference between permanent appointments, ad interim appointments, and temporary appointments. Okay? Alright, so now let's go to a different aspect of the powers of the president. Okay? So, of course, power over all administrative agencies. Yes, of course, the president has the power over its cabinet secretaries and as well as the related administrative agencies under the watch of those cabinet agencies. Like for example, Department of Finance. Ang daming hawak ng Department of Finance, 'di ba? So, Department of Finance may be ang under ng Department of Finance, si Bureau of Internal Revenue, si Bureau of Customs, si Securities and Exchange Commission, si Board of Investments. Ang daming mga offices na sa under ng department. So, syempre, for all legal intents and purposes, may power ang presidente doon. Subject to the hierarchy, 'di ba? Yung flow, 'di ba? Nung organizational chart mo as president, 'di ba? Okay, so then we have this military powers. Okay? We have these military powers. Okay? Pero bago muna tayo punta sa military powers, of course, in relation sa power over administrative agencies, meron tayong tinatawag na faithful execution clause. Okay? So ano yung faithful execution clause? In relation sa power over all administrative agencies, you look at your section 17, article 7. So of course, aside from that control, the president shall ensure that all laws be faithfully executed. So, what does this mean? Siyempre, as the executive department, the job of the president is to implement or execute the laws. Okay, and how are they going to implement or execute that? So, it depende sa sitwasyon if it's directly through the president or it's either directly to the president or it would be through a delegation, di ba? The administrative agencies would be implementing, di ba? It might be through way of an implementing rule of or regulation, or it can be a rule of procedure, more on the realm of your administrative law, di ba? Yung quasi-legislative power mo or yung power of subordinate legislation. Okay? Alright, so that is in relation to the power over all administrative agencies. You have to relate this with the faithful execution clause. Diba? Siyempre, as I said, may limitations yan. Siyempre, kailangan mag-comply ka dun sa valid delegations of power mo. Diba? So alam naman natin, ang test niyan would be, the law should be complete. Of course, insofar as the aspect of the law, but as to the implementation itself, kailangan sufficient yung standards, di ba? So, hindi pa pwede na si administrative agency would do something which is, di ba nga, potestas delegata, non-potest delegari. So, recent example lang, di ba, COMELEC, di ba, na-TRO sila lately because of a certain provision in the resolution 11045, di ba? So, if you can recall, medyo si COMELEC ay nagsingit ng provision doon na ang appointed officials are not deemed resigned. Okay? Which is in contravention with previous rulings sa Parinas versus COMELEC at saka the MR in Quinto versus COMELEC. Well, the Supreme Court found, I don't know, but of course they granted the TRO. As far as we can look at it in the legal lens, it's obvious naman na well, medyo shot to the dark sila. They wanted to test the limits of COMELEC's power in, maybe the chairman wants to to test the limits as to the delegation. Although COMELEC siya, ano siya, constitutional commission siya, the same goes true dun sa presidente, di ba? So, hindi pa pwedeng mag-rise above siya dun sa source, okay? Alright, then we go now to military power. So, first, yung discussion ng military powers natin yan, of course, it started with the IBP versus Zamora case. Then, of course, a more detailed discussion would be found in your David versus Macapagal Arroyo case, di ba? Yung nagkaroon ng state of national emergency dati si PGMA, okay? Note that there are two aspects of the military power of the president. Number one is the calling out power of the president to prevent and suppress lawless violence. This is a power that that the president can invoke. Okay, clear naman yon. May power siya to invoke that power. So he can call the armed forces in order to address any potential security threat or information. Okay, then we have martial law power. So ito yung medyo picky issue on the martial law powers kasi medyo picky yung issue niya is because of our previous history with martial law, okay, and suspension of the writ of habeas corpus. So we have Article 7, Section 18 of your Constitution. So, what is Article 7, Section 18? So, this is the power of the President. Of course, andun yung calling out power, but of course, more on emphasizing the power of the President during martial law. Okay? During martial law. So, essentially, the Article 7, Section 18 says that ano yung mga features niya. So, number one, of course, as of the President, the 1987 Constitution allows the President to declare martial law. But unlike the martial law in 1972, okay, martial law shall be implemented, okay? Martial law shall be implemented only for a period of 60 days. Okay? Then, of course, this is subject to extension. But regardless if it is subject to extension or this is subject to your first declaration, within, I think, 48 hours from the declaration of the martial law, Congress will convene jointly to determine whether or not martial law is proper. Okay, so ang voting scheme sa Article 7, Section 18 is clear. Senate and Congress will vote jointly. Okay, jointly yung vote ng senators and congressmen. Okay, di ba? So yun, di ba? So yun yung doon. So jointly siya. Okay. Siyempre, yung pagbo-vote nila is an affirmation of the martial law declared. Okay? So, hindi tulad noon kasi, 'di ba? Nangyari noon sa martial law, nag-close yung Congress, 'di ba? Pinadlock yung Congress and all of that. In order for that to at least prevent that from happening, binigyan ng say si Congress na okay ba tong martial law na to? Okay? Now, ang tanong, meron bang mga political aspects si martial law? I think meron pa rin naman. Kasi remember that yung declaration ng presidente ng martial law and the subsequent affirmance of Congress, kailangan may factual basis ka. So if you can recall yung case kasi actual 3 kaso to, pero so we go to Lagman versus Pimentel. Okay? So si Lagman versus Pimentel is the case which involves the declaration of martial law sa Mindanao because of the Maute group, raid, di ba, yung Marawi siege, di ba, if you can recall. So, question ni Edsel Lagman yung constitutional, yung legality, kasi nag-convince sila, di ba, nagbotohan sila. So, nag-martial law sa Mindanao, dineclare na Mindanao. So, question ni Lagman yung factual basis, okay, yung legal and factual basis. So, sabi ng Supreme Court, the framers of the 1987 Constitution endeavored to institute a system of checks and balances to limit to limit the president's exercise of martial law and suspension powers, and to establish safeguards to protect all civil liberties. So martial law does not suspend the operation of the Constitution. So accordingly, the Bill of Rights remains effective under a state of martial law. Its implementers must adhere to the principle that civilian authority is supreme over the military. The armed forces is the protector of the people. They must be also abide by the state's policy to value the dignity of any human person and guarantee full respect for human rights. The suspension of the privilege of the writ of habeas corpus shall only apply to persons judicially charged for rebellion or offenses inherent in or directly connected with the invasion. So during the suspension of the privilege, any person that shall be judicially charged within 3 days or otherwise will be released. Okay, so this is an affirmance do sa provision ng Article 7 Section 18 na limited lang yung martial law sa mga sa mga involved, like for example sa Marawi, yung mga involved na sa Maute, applicable yung suspension ng writ. Pero note that because of the martial law experience in 1972, practically nag-suspend ka ng writ doon eh. So yung suspension ng writ mo, 'di ba? Kailangan i-ano mo siya, kailangan mong i-affirm mo siya by way of act of Congress. Hindi yan tulad doon na it's a political question on the part of the executive. Okay? Hindi na siya ganun yung ano. So, and remember, note natin, di ba, na yung civil courts are still open during a state of martial law. Even doon sa places where it was declared. Kasi remember, di ba, if you can recall si Olaguer versus Military Commission number 2, hindi pwedeng itry ang mga civilian sa military courts. Diba? So, this is in keeping with Olaguer that hindi pa pwede na ma-try yung mga civilians sa military courts. So, kaya nga sinasabi na open lang yung military courts. Now, if you forget all of this, syempre, pwede mo namang sabihin na constitutional supremacy. Diba? Kasi, diba, ang constitutional supremacy, remember that yung limitations sa Article 7 Section 18 are more or less creation of reasonable limitations so that civilian rule would still be preserved. Kaya pwede mo sabihin doctrine of constitutional supremacy kasi kailangan di ba? Bakit ka magiging under the subject of military justice, di ba? So, that's the point of your Lagman versus Pimentel, okay? Then we have diplomatic power. So, of course, the president has this power of creating diplomatic relations. Even if this, sabihin na natin wala to sa Constitution, okay? Kasi meron particular, we'll discuss yung transformation clause later kasi. Pero, even if this is not included in the Constitution, this is a traditional power by the head of state, di ba? To establish diplomatic relations. So, di ba, if you can recall sa PIL, may mga formalities kasi yan, di ba? Na sometimes you want, pag gusto mo magsimula muna, pag bago yung nation, you have to adhere with recognition. Then, kung tapos na kayo dun sa recognition phase, yung creation of diplomatic relations. So, di ba, kailangan mong, may mga formalities yan, di ba? Like, mag-establish ka ng diplomatic mission or magpapadala ka ng letter of decreance at saka yung agreement mo, or kung consul naman, yung mga exequatur nyo, di ba? You need to comply with those, okay? Then, of course, may power ang presidente. Then, we now go to the power of entry of the power of the president to enter into a treaty or agreement, okay? So, ito yung transformation clause natin. So, nasa Article 7, Section 21 siya. So, what's the importance of this clause? Number one, as a rule, di ba, if you can recall si Ichong versus Hernandez, di ba? That's, I think to an extent, si Laurel versus hindi Laurel, si Indre Garcia, di ba? When we speak of treaties, di ba? Yung treaty itself is not law, di ba? It's not necessarily law, okay? Why is it that so? If we can recall, di ba, anong klaseng state ba tayo, ang Philippines, insofar as adherence to PIL is concerned? We are a dualist state, di ba? So, ibig sabihin nung di tayo kasi monist, dualist tayo. Kasi pag monist, matik yan, accepted yung PIL. Example, inintroduce mo PIL sa, if you introduce PIL in the argument, courts will allow it, okay? Pero sa Pilipinas, we are adhering to the dualist principle. Well, dualist siya in a sense na before a treaty or a law or an international or anything which involves international law would be part of the law of the land, kailangan ng enactment from Congress. Okay? Kailangan enactment from Congress or any act that would ratify that. So, si transformation clause mo is with regards sa treaty. Kasi sa treaty, mag-sign ng treaty. Okay, nagpirmahan ng treaty. Okay? Ang tanong ay is, bound ba ang Philippines dyan? Hindi pa. Hindi, bound ba ang Philippines? Yes, bound siya. Kasi diplomatic issues yan eh. The question is, can the treaty be treated as law? Is it an equivalent of law? The answer there is no. Because remember that remember that remember that laws, okay? Remember that laws, okay, they're not equivalent to treaties. At the same time, although if you may have a treaty, if let's say your law, di ba, sabi nga sa Ichong versus Hernandez, if the law pertains to something which is close to police power, di ba? You cannot bargain police power to as against a treaty. So hindi mo pwedeng isang layong national laws natin. Yun lang masasabi ni Chong eh. Meron tayong mga national or municipal laws. It would prevail over treaties in the absence of any in the absence of any ratification or any act accepting that treaty. Okay? That is why meron tayong transformation clause. Na kung yung treaty mo would be, in order for the treaty to be valid and binding as if it is a law, you need to ask Congress to ratify with the vote of 2/3 yung treaty. That act of ratification would commence the fact that the treaty or convention is now considered as law. Okay? So, yun yung doon. So, yun yung magiging, that's the point of your ratification. Okay? Alright, so, then we have the budgetary powers. Sabi ko, as I said, we have to relate this with yung power of Congress. Diba? As we discussed a while back, Congress has the power of the purse. Siyempre, sila yung mag-e-enact ng general appropriation ng budget mo sa general appropriations mo for a particular year. Of course, there are subject to limitations, 'di ba? Kailangan clear siya, kailangan identified siya sa budget, 'di ba? You have to comply with the constitutional provisions. Now, yung budgetary powers niya, this is the executive aspect that we're going to discuss. Paano executive aspect? Makita nyo to malamang sa recent budget deliberations, 'di ba, involving the Vice President. So, syempre, ano ang mangyayari? So, of course, kailangan magkaroon, as ideal, hindi naman necessarily required. Ideally, meron ka dapat na general appropriations law every year. So that the executive department, 'di ba? Syempre, the Congress will approve the GAA, 'di ba? But of course, ba't kailangan ng executive yung GAA? Kasi syempre, may mga programs and policies ang administrasyon, 'di ba? Example, the administration wants better education, so kailangan niya ng pondo sa education. So remember na yung presidente, kanya-kanya ang administrations natin, 'di ba? They want to implement their policies, 'di ba? 'Di ba? Hindi ko alam anong policy ni BBM ngayon. Wala akong naririnig na parang moniker niya. But if you can recall the previous presidents, 'di ba? Yung mga example si Garcia, Filipino First Policy, 'di ba? Si Era para sa masa daw, 'di ba? Yung mga ganun, 'di ba? May mga policy sila. So more or less their policy that they manifested or that they espoused during their campaign as presidents magre-reflect yung policies na yon dun sa kanilang mga enactments, di ba? So, syempre, kailangan mo ng particular funding, di ba? Para ma-convince mo yung Congress na this is for my policy, di ba? So, yun yung point yun yung point ng power. So, ano mangyayari ngayon gagawin ng gobyerno ngayon, ng executive department? So, ang importante dyan is, unahin muna natin si informing power. So, nalala niyo si informing power, yan yung SONA. Di ba? Ano ang importance ng informing power? So, number one, of course, the president has to speak, di ba, sa SONA. Okay? Pero may particular importance, syempre, si informing power. Okay? I-relate mo siya sa opening ng Congress every fourth week of July. Okay? So, the president exercises the informing power to the SONA. Then, Congress, dahil dyan sa opening ng Congress, that's the start of a new session. Diba? So, nag-SONA, start na new session yan. Tapos, di ba, magre-recess sila usually late, tapos, mag-open ulit sila ng July. Diba? Right now, medyo early ang closing. Kaya, itong mga Quadcom na naririnig nyo sa TV, they're trying to hurry it up. Kasi, usually, pag election year, the recess is earlier. It usually ends I think, depende kung Pebrero o Marso. Pero, after nun, puro campaign period na kasi yun eh. So, medyo distracted na yung mga senators because of the election. Okay? Pero yun yung importance nun. Yun yung reckoning point. Ano kung bakit yun ang reckoning point? Di ba July yun? Di ba? By August, mag-uutos na si Presidente through the DBM is going to ask all of the offices, di ba? Lahat ng offices na under niya. You have to plan for the budget. So, si-set up nila anong kailangan budget sa isang opisina. Okay? So, pag na-set up nila yung budget, ibibigay nila sa Congress yon. Di ba, ang gagawin ng Congress, magkakaroon na ng budget call. Di ba? So, pag nag-budget call ka, yung mga executive departments will now present yung plans nila for next year. Okay? So, relate natin kay Vice President. Di ba? So, nag-budget call yung nag-budget call na nitong August. So, syempre, lahat ng mga departments, nagbigay na ng proposed budget. Now, of course, subject to in the exercise of the check and balance power, after ng budget call, magkakaroon na ng deliberations, diba, sa budget. So, syempre, titingnan nila kung okay ba yung budget na yon. Now, depende sa view kasi yan. Okay? So, yung iba kasi, ina-argue nila, yung iba kasi, pag nagsuscrutinize, napansin nyo dito kay VP Sara, they're scrutinizing it on the basis of past performance. Napansin nyo, di ba? Past performance yung dahilan eh. Kaya di ba hino-hold nila yung budget? Past performance. Iba naman kasi, may iba ang view, like si PGMA. Iba naman ang view niya. Ang view naman kasi niya, kung tutusin, kaya sabi, ba't nyo tinatanong ng ganyan si VP Sara? Is because, di ba, nanghihingi ka ng budget eh. Di ba? Siyempre, sasabihin mo, ito yung program ko dun sa office ko, di ba? May mga programs akong gagawin, bla 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 bla, di ba? Bakit mo questionin yung pagbigay ng budget? Parang lumalabas, sandali, ba't hinihinto mo yung bigay ng... Parang lumalabas ngayon, example, sabihin natin, yung past performance mo is not desired, di ba? Isa-slash yung budget mo, or minsan, in the case of, minsan, parang pang-asar lang, binibigyan na zero budget, di ba? Minsan ng Kongreso, di ba? Usually UP lagi na bibiktima sa ganyan na slash ng budget eh, di ba? So yun yung ano diyan. So you have to consider that. So isa-slash yung budget. So yung mga deliberations is important to determine. Now, yung iba, well, sinasabi nga ni Sara, di ba, na medyo shiminit daw, di ba? Yung nga lang kasi, ay ina-aprobahan niya yung kanyang budget, di ba? So, iniipit yung budget niya. Of course, siyempre, you can also have this view kasi na, well, you're anticipating on future use of the budget. Kung magkaroon ng problema, sakat ko talaga may issue ka doon sa budget, di magkaso ka sa ombudsman o sa COA, di ba? Which is yun naman ginawa ng COA kung tutuusin. they are trying to flag BP Sara. Nag-issue na sila ng mga NDA. Okay? Partial NDA nga sila. Ang problem kasi sa NDA din kasi is, if you go dig sa rules ng procedure ng COA, yung NDA kasi, it's just a notice. Tandaan nyo, ano ba term? NDA, Notice of Disallowance. Pag sinabi mo kasi Notice of Disallowance, binibigyan ka ng notice. So, pag notice yan, ibig sabihin yan, hindi pa yan final, di ba? So, totoo lang. But hindi yan final? Kasi ang under existing COA rules, nire-require ng COA na binigyan ka ng NDA. Nire-require ka ng at least 6 months or 180 days to explain or show how the expenses were made or how the expenses were defrayed by the office. Siyempre, pag lumagpas na 6 months, magsasubmit ka na nga. Minsan na pwede mo extend yun eh. Sa practice, pwede mo extend kasi yun. For example, hindi mo pa mag-gather yung document. Request ka na extension. Siyempre, alam naman natin ang extension, cross fingers lagi yan. Pero hindi necessarily, pero siyempre, there's a chance na mag-grant. But the point is, the one who is the subject of an NDA, maybe, the one subject may explain, di ba? Kaya nga, kung tutuusin, bakit mo explain yung past performance mo? Hindi pa naman final yun. Eh, alam naman natin, minsan ginagawa dyan, delayed yung ano, tapos explain na lang later on. Eh, syempre, hindi ko alam kung magic yan o hindi. Pero the point is, you know, binibigyan ng 6-month period yan for the one addressed to the NDA to comply, di ba? So, yun, nagkakaroon ng hold. So, mangyayari, magsaset na ng budget. So, after setting the budget, yun na, ilalagay na sa General Appropriations yung bill. Tapos, aprobahan na ASGA. Ngayon, syempre, may mga certain items doon, pwedeng i-item dito ng presidente kasi baka sa tingin niya, hindi pwede or hindi. Now, similar to the DAP case, kailangan particular, okay, ang iyong item sa budget, okay? Diba, doon sa DAP case, sa Belica versus Ochoa, diba? Dineclare unconstitutional ang pork barrel because the items in the PDAF are items which, since alam naman natin PDAF/PAN yan, walang specific item. Sobrang generic lang kasi sasabihin lang for projects eh. Sabi ng Supreme Court, hindi pwede. Kailangan yung deklarasyon mo sa PDAF is kailangan naka-budget yan. Although, alam naman natin, dahil sa proklamasyon na yun ng Supreme Court, siyempre, ang technique dyan, babaguhin lang nila yung pangalan ng PDAP. Ibang term, pero it's still the same animal. Ganun ang lusot doon. Okay? That's the reality of it. Sa presidente naman, may nag-set ka ng budget. Ang tanong is, siyempre, hindi natin masisisi na yung mga budgets natin, hindi naman nagagamit. Di ba? Hindi naman nagagamit yung budget all throughout eh. Or kung magaling yung presidente, they can use that as an opportunity para mag-ipon. Di ba? But the next question is, can you impound? Okay? Kasi noon, tagal ng issue na pwede bang i-impound ng presidente yung budget. So, ibig sabihin, i-impound niya for future use. Siyempre, siya may hawak ng executive department, may faithful execution clause eh. So, pwede ba siya mag-impound ng budget from a previous Sabi na sa Arroyo versus Aquino, hindi. Yan yung kaso ng DAP. Yung DAP program ni Pinoy. So, yung DAP program na yun, it involves the concept of impoundment. Sabi ng Supreme Court, similar to PDAF, kailangan itemized yung DAP na yan. Isa pa, syempre, pag ginamit mo yung DAP sa different project, di ba may previous original purpose yan, isn't it that you're practically committing technical malversation already? Kasi di ba, alam naman natin sa technical malversation, you have to yung item legal nasa budget pa rin, ginamit mo na sa ibang project. So, that would be tantamount to technical malversation kung yung perang inimpound, gagamitin mo ulit from public use. Kailangan i-reenact mo siya or i-notify mo yung Congress for that budget to be reenacted. Okay? Sa sanggunian, ganyan din ginagawa, if I can recall. pag may ganyang mga special issues, may sobra, papare-enact ulit sa sanggunian yung budget para at least klaro. Kasi once na hindi kasi klaro yan, maraming susceptibilities in so far as the president is concerned. Pwede siyang technical malversation or worse, baka plunder pa, di ba? Indirectly, di ba? So, it might be it might be a case. So, kaya dineclare siya unconstitutional. Okay? Alright. Okay. So, other powers. Okay? So, other powers, meron yung sa monetary board, may power siya to convene. You just note that. Okay, then, pa ba na left out ko? Yung concept na ex officio officers. Okay? Concept na ex officio officers. So, di ba, related to sa appointing power ng presidente. Okay? So, if you can recall, di ba, yung kaso ng Civil Liberties Union versus Executive Secretary, di ba? So, the Supreme Court held there that yung offices mo, you cannot appoint offices in so far as di ba? So when we speak of offices, di ba? We have this di ba? So Clear lang natin, okay? Kasi we will relate this dun sa kaso ng public so di ba sa Civil Liberties Union, di ba, bawal yung multiple positions, di ba? Of course, it's clear naman eh. So example, paano ba to? Kaya di ba napansin niyo, di ba, yung mga sila Senator Angara or si Ralph Recto, senator sila pero they resigned, di ba? They resigned. Kasi number one, hindi tayo parliamentary. Number two, may rule on prohibition on having multiple positions in government, di ba? It's part of your incompatible office and prohibited offices functions sa Article 6 and Article 7. But the exception there, okay, is pag in-appoint mo ng ex officio, okay? Bakit exception ng ex officio? So I think the case here would be Public Interest Center versus ELMA, okay? Kasi pag ex officio siya, the appointment is not directly made by the president. Okay? It is an appointment, remember, ex officio, walang compensation ng ex officio. It's just, the office is created for the purpose of formality, assigning it to a person, but there is no additional compensation. Kasi if you note, aside dun sa multiple offices, kaya binaban yung multiple offices, if you read back si Civil Liberties Union versus Executive Secretary, aside doon sa multiple offices, magkakaroon ka ng double compensation. So, ang hinihit mo kasi doon dalawa. Si multiple office, hindi ka pwede mag-hold. Number two, syempre, kapag multiple yung offices mo, ang assumption mo, dapat sahod ka. Example, presidente ka, tapos may senador ka. Sabihin natin, senador ka, tapos cabinet secretary ka. Diba? Parang, kung isipin mo, may sweldo siya as senator, may sweldo siya as cabinet secretary. Yun yung binabawal, okay? Yun sinasabi sa Civil Liberties Union na case. Hindi ka pwede magkaroon ng multiple positions kasi, multiple positions yan. You have some appointed would suffer. But of course, that's also to prevent double compensation. Kasi magkakaroon ng double compensation instance. Kaya yung ex officio, hindi siya covered sa prohibition, is part of an exception because, number one, ang ex officio office is created by law. Okay? It's created by law. Okay? Since created siya by law, okay? Since created siya by law, it's going to be, walang appointment ng presidente. Or kung mag-appoint na ng presidente, it's not because the president appointed it as he wants to appoint the person. Kasi naka-designate na yung position like ex officio si Senate President o ex officio si DOJ. Siyempre, kung sino may pwesto mong DOJ Secretary doon or kung sino mang office or senator na representative, walang additional compensation. Wala yung office na is set by law. Also, pag ex officio ka, the assumption is wala kang sahod na dagdag. Kasi ex officio siya eh. there's no ano, there's no link, or there's no way that, you know, the president has an direct involvement with the appointment. So, at the same time, ano ka, hindi ka mag-double compensate. Okay? Now, a little bit of a slide, kung naalala nyo sa bar exam nung last time, di ba? Di ba? Ang tanong is, ano pa ang other effects ng ex officio officers? Di ba? Doon sa bar exam question, kiniklaim niya na alter ego sila. Okay? Doon sa bar question, if you can recall. Siyempre, of course, it came from a particular case. Sabi ng Supreme Court sa case na yun, I think it's Napo Coriata versus COA. Okay? So, sabi doon sa case na yun, yung particular case na yun, ang ex officio, okay, if your office is ex officio, okay, kasi nangyari, may assigned na cabinet secretaries kasi doon sa GOCC. So, pinag sila ng COA kasi double compensation eh. Ang sagot ng sagot ng officers, alter ego naman kami. Di ba? Ang katwila, alter ego. Sabi ng Supreme Court, hindi applicable yung alter ego doctrine. Okay? So, hindi mo kailangan, ano yun? So, kung alter ego siya, hindi applicable yung alter ego sa ex officio officers. Okay? So, anong nangyari, na-disallow pa rin yung mga benefits. Okay? So, double check in. Natanong sa bar yun eh. Okay? So, alright. Then other powers, of course, yung residual powers, kung wala nang ibang power ang presidente, meron siya mga powers na implied. Okay? So I think, but note that, well, it depends on how are you going to argue this. Remember that the main case on residual powers would be the case of Manglapus versus Marcos. But note that in Marcos versus Manglapus, okay, the issue there is whether or not a corpse of the corpse of President Marcos should return to the country. So, wala kasi mahugot na power ang Aquino administration, so they resorted to the discussion on residual powers na pwedeng pigilan ng presidente yan. Even despite the supposed harking of the Marcoses then of their right to travel and right to return and all of that, okay? Note that yung kaso na yun is medyo political in nature yan. Kasi hindi ko alam kung yung residual powers is it a valid concept, because I think if you read my books, I kind of discuss na I am a bit of a disagreement with the residual powers concept, kasi marami tayong mga rulings sa Supreme Court na, well, we're saying na walang power sa Constitution. 'Di ba? One good example, LGCs. 'Di ba? Yung LGCs natin, even as late as sa case ni Pimentel versus Aguirre, 'di ba? Diba, sabi sa Pimentel versus Aguirre, diba, alam natin yung laging issue, laging pinupukol sa mayor to, na ano ang powers ng Office of the President when it comes to local government officials. Ibang sabi, and even reiterate, tagal ng cases yon, even as early as 1950 sa Lacson versus Roque, and still holds true even in Pimentel versus Aguirre, na ang LGUs only have supervision from the president. So, yung mayor natin, supervisory siya. So, di ba, yung interpretation nun kasi, wala kasing nakalagay na hindi siya supervisory. Di ba? So, since supervisory na siya, hindi pwedeng mag-under the thumb yung presidente. So, ibig sabihin, walang powers ang presidente over LGUs. Di ba? It's clear. Di ba? And even it's not in the Constitution, it's still the concept. Now, kung papasukan mo na residual power, so ibig sabihin, pwede natin i-counter-argue din na pwedeng maalisin kasi may residual powers ng presidente kung di niya trip, di ba? I think it would be a little bit far-fetched. So parang ang dating ko nga dun sa Marcos versus Manglapus, parang, well, it's still parang Estrada versus Arroyo. These are cases which toe down the political line. Diba? So, yun. So, I think I have discussed enough on the presidential powers. Okay? So, So yun yung presidential, yun yung powers ng president under the 1935 Constitution. Okay?